Now, very important contentious topic, quota in promotions. There's an earlier video on quota, basically on reservations, the whole process of reservation, how constitutional provisions evolved in India. You must watch that. You can search by the name of Reservations in India, Tarun IAS or Amit Tiwari, and you can find that video. But today we are going to talk about quota in promotions. Okay. Why this has been in news? Because basically DOPT, Department of Personnel and Training, okay, has asked all the departments within the central government to formulate or to collect data regarding the regarding the inadequacy of representation of SC, STs and OBCs in the central government. Okay. Now, why this? What another news? Government lays down norms for quota in promotions. The first point. The second point. This is from the Hindu. This is from the first post. Quota in promotion. Center asked departments to collect data on inadequacy of representation of SCs and STs. अब ये important point ये है कि why has the government, or basically center means यहाँ पे DOPT, Department of Personnel and Training, which is under MOPPNG. ठीक है? Let me get through this. What is the full form of Ministry of Personnel? This is Ministry of Personnel. Okay. Ministry of Personnel, Public Grievances, Personal Pensions and Public Grievances. Okay, this is the ministry which basically does all the hiring for central government. Okay, like UPSC is an autonomous body, it is under a constitutional body. ठीक है, तो cadre control कौन करता है? DOPT, Department of Personnel and Training, which is under the Ministry of Personnel, Pensions and Public Grievances. Personnel means you can consider that this is the HR ministry, Human Resources Ministry of, not Human Resources Development, that is the different, now it has become a Ministry of Education. I'm talking about the HR department, like all companies have an HR department, this is the HR department of government. Now, the DOPT has asked all the central governments, or all the departments, all the ministries in the central government to collect data regarding the inadequacy of representation of SC, STs in all the posts. Okay, now we look into this, ki why has this happened all of a sudden? Prior to that, we'll be looking into what are the constitutional provisions regarding reservations in India. The first one is Article 16(4). It provides that state can make any provision for the reservation in appointments. ठीक है, very important. Article 16 talks about reservation in appointments. Article 15 talks about reservation in education. Okay, so Article 16 talks about that. Article 16(4) says that the state can make any provision for reservation in appointments for the posts in the in the government for any backward class. See here, backward class. It is not written SC, STs or OBCs. It is called any backward class of citizens who, in the opinion of state, are not adequately represented. Now you understood why adequate representation. Data on inadequacy of representation. That means the constitution says that the government can reserve seats in favor of a special backward class if the government considers that specific backward class is inadequately represented in the services under the state. Now, state here not only means central government or state government, it means every organization that is controlled by the state. State means both central government, state government and any other bodies. ठीक है? Okay, similarly, Article 16(4)(a), it was later inserted. It was not provided in the original constitution. It provides that states can make any provision for the reservation, ठीक है, reservation in matters of promotion. ठीक है, Article 16(4)(a) talks about the reservation and promotions. It was not originally provided in the Constitution. It was later on added to the Constitution. ठीक है, in favor of scheduled castes and scheduled tribes. Now, here very important point is Article 16(4) talks about any class, any backward class of citizens, any backward class of citizens. But 16(4)(a) specifically talks about scheduled castes and scheduled tribes. ठीक है, if they are not adequately represented, again adequate representation is the point here. ठीक है, तो public services में, yes, government jobs में, in the very layman language, public services में या government jobs में, if the SCs and scheduled castes and scheduled tribes are not adequately represented, the government thinks that the government can then reserve seats for promotions as well as in the employment. ठीक है, it was inserted by 77th Constitutional Amendment Act 1995. It is very important. It is very important. Now Article 16(4)(b), again it was added by 81st Constitutional Amendment Act 2000. It says that the unfilled SC/ST quota should be carried forward to the next year. Okay, for any reason, if the SC/ST quota seats are not filled this year, so they can be filled the next year. Carry forward rule. This is carry forward rule. Okay. Now one important article, Article 335. It recognizes that special measures need to be adopted for considering the claims of SCs and STs to the services and posts in order to bring them at par with the other communities. Article 335 is an enabling provision. It enables the government, it empowers the government to make laws to bring SCs and STs to the power at the par of other communities by making specific kind of reservations in the favor of these people, ठीक है, to make them adequately represented. Now 82nd Constitutional Amendment Act 2000, see, it was 16(4)(b) was inserted by 81st Constitutional Amendment Act 2000. Now 82nd Constitutional Amendment Act said that inserted a condition at the end of Article 335. Article 335 के end में क्या किया, एक constitution किया, that enables state to make any provision in favor of the member of SC/STs for relaxation in qualifying marks of any examination. ठीक है, तो the whole process of the crux of the reservation is point 1, point 2, point 3, point 4, point 5. If you are done with these 5 points someone, you need not learn anything else apart from some Supreme Court judgments in the process of reservation, and you will understand the whole thing what reservation is in the basically in jobs. ठीक है, so the first is 16(4). it can provide that state can provide for reservation for any backward class of citizens if the state believes that they are inadequately represented in the services of the state. 16(4)(a) was later inserted by 77th Constitutional Amendment Act 1995. It says that the provision for reservation of scheduled castes and scheduled tribes, not any backward, any OBCs are not, the 16(4)(a) is not for OBCs but only for SCs and STs. Okay, it says that the scheduled tribes, if they are not adequately represented, the state can make any provision for reservation in promotion. So 16(4) talks about reservation in employment. 16(4)(a) talks about reservation in promotion. 16(4)(b) talks about carry forward rule. Okay, Article 335 talks about an enabling provision for the governments to make them empowered to make laws in the favor of backward citizens. And 82nd Constitutional Amendment Act 2000, it enables, ठीक है, तो this is यहाँ Article 335 what it talks about. It talks about special measures. So special measure, one such special measure has been added by the 82nd Constitutional Amendment Act 2000. What is it? It is that the qualifying marks can be relaxed. That is, the cutoff mark can be relaxed for the SC and STs so that they can be brought at the par with the other class of citizens. Now, evolution of a reservation, and it's a very interesting topic, and how a conflict between the judiciary and the not basically judiciary, yes, the judiciary and the government has taken place, and how has now how has the kind of reservation that we are seeing in country today, we'll see how it has evolved since time. Okay, so the very first case was Mandal judgment in 1992. Now, Mandal Commission was formed by Janata government in 1976, 1978 basically, and it submitted its report on the backwardness, OBC basically. ठीक है, OBC community की assessment के लिए Mandal Commission बना था, and it submitted its report, but its report was not considered by any government until 1992, when the VP Singh government took this report out from the cold shelves and then implemented the recommendation of Mandal judgment. There was a lot of violence against this implementation of this judgment, and a lot of riots also took place, but nothing happened, and the judgment, the Mandal case, the Mandal Commission recommendations were implemented. Now, what was the Mandal Commission recommendation? The Mandal Commission recommended that 27% reservation should be provided for OBCs, okay, which was Mandal judgment 1992. It was challenged in Supreme Court. Okay, it was also called Indira Sahni judgment. Indira Sahni judgment. Indira Sahni case. In that case, Supreme Court upheld the 27% reservation that was recommended by the Mandal Commission, and it put a limit of 50% on the total reservation. It said that the total reservation cannot exceed 50% of the total seats. Like if there are 100 seats, the total reservation cannot exceed 50%. Along with the 27% reservation for OBCs, 10% reservation was provided for EBCs also, economically backward classes, which is now economically weaker section, EWS. Okay, so it was also struck down. It was struck down that 10% reservation for EBCs, economically backward classes, is not sustainable, not constitutional, because it said that economic backwardness is not a criteria for provision for any kind of special. That means economic backwardness only. The very important point we need to note here is only economic backwardness cannot be formed a basis for provision of reservation. ठीक है? What it should be like compensated with is social backwardness, socially and economically backward. तो SEBC, socially and economically backward, are OBCs. ठीक है? तो EBC reservation was struck down at that point in time. And very important judgment, the very important point was no reservation in promotions. Promotions में किसी प्रकार का there will be no reservation in promotions. ठीक है? So this was in 1992. But in 1995, 77th and 85th 77th amendment took place in 1995. Okay. What happened? Again, inserted Article 16(4)(a), we looked at that, which provided for reservation in promotions. ठीक है? 1995 में. The ground for reservation in promotion was inadequate representation of a community. ठीक है? फिर 2001 में 85th Constitutional Amendment Act and consequential seniority was added. Carry forward rule that we saw and consequential seniority. That means, what is consequential seniority? That means if a person from reserve category and a person from unreserved category both have been selected at the same time, and due to the reservation in promotion, the person from reserve category gets promoted early as compared to the person from unreserved category. What happens? Although the both were selected at the same time, but since that the person from reserve category has got promoted, he becomes a senior. and therefore he will carry on his seniority. This is consequential seniority despite the fact that the both were selected at the same time. This is called consequential seniority. उसके बाद क्या हुआ? नागराज केस 2006. This is a very landmark case in the whole process of reservation. It upheld that government can provide reservation in promotion. Again, reservation in promotion was under challenge. And again, Nagraj case also, Supreme Court said that reservation provision in promotion can be provided given that the government has quantifiable data of inadequacy of representation. Why? Because 16.4a, all these articles talk about the fact that if in the opinion of government, a specific community, if it is underrepresented in the services of the state, then the benefits of reservation can be provided to that specific community. Then Supreme Court said that what is the basis of your opinion? What is the basis of your opinion? It said that the basis of the opinion should be quantifiable data. That is, there should be data about the inadequacy of the representation. You cannot provide reservation in promotion without quantifiable data. Okay. And it should not affect the efficiency of the administration. Article 335 itself talks about the efficiency of the administration. Okay. And again, Nagraj case also said that sorry, the reservation should not affect the efficiency of the administration. So this was the whole evolution process, how reservation has evolved in India. And again, two more cases that we'll be looking at are in 2019, Supreme Court upheld the reservation in promotion and validated the Karnataka Reservation Act 2018. It introduced definition of administrative efficiency. Okay? In Nagraj case, the judgment was that the reservation should not affect the efficiency of administration. Okay, but in this case, it also introduced what should be the definition of efficiency of administration. Okay? In 2020, Supreme Court said that it is no fundamental right which inheres in an individual to claim reservation in promotion. Okay? So reservation in promotion cannot be a fundamental right. Okay? It is only an enabling provision for the government, that government can make law. But people cannot claim that the government has not made law and it is violating my fundamental right. No, it is not a fundamental right. Okay. So I hope you understood this whole reservation promotion thing. If you have any questions, you can ask me in the comment section. I will take them very happily.